Article 3, Section 1 of the Constitution states that the federal judges shall hold their offices during good behavior, which means that, so long as they are not found to have broken the law, they serve for as long as they wish. The framers thought this would best protect judicial independence. The very first act of Congress came in 1789, before the ratification of the Bill of Rights in December of 1791. That was the Judiciary Act. It established a 6-justice Supreme Court, 13 distinct district courts, and 3 circuit courts that would hear appeals from other states. Congress, with the Judiciary Act of 1801, reduced the number of Supreme Court justices from 6 down to 5. Thus, you can see one check on the power of the Supreme Court is that Congress controls the number of justices who may sit on the court. But the Supreme Court checks Congress as well. 2 years later, in 1803, Chief Justice John Marshall ruled that Congress had exceeded its constitutional authority in writing the Judiciary Act of 1789. In Marbury versus Madison, William Marbury, the plaintiff bringing the suit to the court, had been nominated Justice of the Peace by the second President of the United States, John Adams, in a midnight appointment. Because the president appoints federal judges, Adams had made 217 patronage-based last-minute appointments to Federalists. Thomas Jefferson, the third president, and his Secretary of State James Madison, who later became the nation's 4th president, refused to finish processing the judges by issuing the official documents or commissions. Under the terms of the Judiciary Act, the Supreme Court could force the Jefferson administration to give Marbury his money. That it emphatically is the providence and duty of the Judicial Department to say what the law is was the court's ruling. So in this important case, Chief Justice John Marshall established the principle that became known as judicial review. Court would provide a mechanism independent of the legislature and executive branches to prevent laws violating the spirit of the Constitution. 2 other important court cases where the Marshall Court had decided were the 1810 case, Fletcher versus Peck, and the 1819 Dartmouth College versus Woodward. In Fletcher versus Peck, Marshall upheld the principle that matters of constitutional interpretation should be heard in the highest courts of the land. And he also stated that states could not impair the obligation of contracts between governments and individuals. Dartmouth College focused on New Hampshire's attempt to transform a private corporation, Dartmouth College, into a state university. Chief Justice Marshall decided that Dartmouth's original charter was a contract and was thus protected under the constitutional prohibition against state interference in contracts, essentially stating that once a state had chartered a college or business, that state had surrendered its power to alter the charter and, in large part, regulate that business. The result of the Woodward win was that creditors would find it easier to pursue their debtors in cases brought before the courts. From 1801 until 1869, 5 justices sat on the Supreme Court. But since 1869, 9 justices have sat on the Supreme Court. President Franklin D. Roosevelt tried to change this in his 1937 court packing plan. The plan called for the addition of a new judge to the Supreme Court whenever an incumbent refused to retire at the age of 70. The Supreme Court in 1937 was comprised of 9 judges, 6 of which were over the age of 70. The plan called for an expansion of the total number of judges to 15. The reason FDR wanted this was because he was afraid that the Supreme Court would continue to overturn his New Deal programs that he had managed to get through Congress. As a result of President Roosevelt's New Deal, the federal government became a more important agent of change than in previous presidential administrations. But the Supreme Court had already overturned 2 of his new alphabet agencies to alleviate the effects of the Great Depression: the National Recovery Administration and the Agricultural Adjustment Administration. Publicly, Roosevelt did not give that reason, of course, that they were too efficient for him. Instead, he claimed that the Supreme Court was behind on its docket, meaning not working efficiently enough. Both conservatives and the public liked the idea of an independent judiciary and believed in the system of checks and balances established in the Constitution, as discussed in Module 1, and turned on Roosevelt. Even many of FDR's Democratic supporters in Congress had problems with his plan, so he was forced to back off. The number of Supreme Court justices has become part of the informal constitution that keeps government operating. Whatever that number, it will usually be odd unless there's a vacancy, because that will prevent tied decisions. The The Supreme Court decides less than 1% of cases in the United States. The term plaintiff is used for the party bringing the case to the court, and defendants are those that must defend their positions in the court. Under original jurisdiction, a case is heard for the first time, whereas under appellate jurisdiction, a court hears a case on appeal from a lower court and may change the lower court's decision. The Supreme Court usually functions as an appeals court. The cases that the Supreme Court decides tend to fall into one of four categories. The first, the lower courts hearing the case have made conflicting decisions. The second, a lower court's decision is at odds or potentially conflicts with a previous Supreme Court decision. The third, the case involves an issue with far-reaching national consequences. And in the fourth case, the Solicitor General, who is a presidential appointee within the Justice Department, argues on the government's behalf and urges the court to take the case. For a case to be heard by the Supreme Court, the court must issue a writ of certiorari, which calls for a lower court to send to the Supreme Court the records related to that case. At least 4 of the 9 judges must agree to issue a writ of certiorari, so this is known as the Rule of 4. There are different types of opinions the court may issue. First, a majority opinion, which states why the majority of justices came to the decision they did. And sometimes justices write a concurring opinion, which means that they came to the same conclusion as the majority, but for different reasons. The third type, a dissenting opinion, is written by justices who did not agree with the majority and states their reasoning for differing from the majority. A unanimous decision in which all judges agree is very rare, in part because judges have differing ways of interpreting the Constitution. Some federal judges, usually those that are more conservative, interpret the Constitution in a narrow way, and they are called strict constructionists. They believe in adhering strictly to what is explicitly written in the Constitution. The third president of the United States, Thomas Jefferson, was a strict constructionist. He believed so strongly in a Republican, lowercase r, ideology that the ideal citizen was an independent farmer and that the new nation should expand over space that he went against his strict interpretation of the Constitution and brought the Louisiana Purchase from Napoleon of France in 1803. Even though nowhere in the Constitution did it explicitly state that the government could buy land from a foreign power. Others, usually liberal judges, are loose or broad constructionists. They view the Constitution through the lens of evolving moral and cultural standards of the time and adhere to the underpinnings of the principles of the Constitution. We'll talk more about this in Module 1. For now, review the video and go over the questions and continue to read in your textbook.